Hello, my name is Kane. Hello, my name is Jeff. This is Castle Doctrine, your home defense network. I don't understand why I continue to have the problem. Minnesota is trying to change into a stand your ground state. We are currently a duty to retreat state. And here is a biased news report on what stand your ground isn't. And I'm going to play it. It's only going to be a couple of minutes, but I want to listen. They don't have anything in this report that contradicts their version. Okay, let's get this thing started.
Many Minnesotans are speaking out against two controversial bills that would loosen the state's gun laws. Yesterday's hearings brought out big crowds, even filling an overflow room at the state capitol. One of the proposals, known as the Stand Your Ground bill, would relax Minnesota's self-defense laws, allowing people to use deadly force if they feel threatened. The other would allow people to carry a gun in public without a permit. Nearly everyone who spoke during the 2-hour hearing opposes the measures.
If this bill passes, people who couldn't pass a criminal background check and have never learned how to handle a gun safely would be able to carry one in public. How would that protect public safety?
Don't you love it how I have to talk after this guy? Don't you love it how he leaned forward and said, how does that protect the citizenry of Minnesota? Well, let's work on his fallacy in the first place. Minnesota is also putting into another law about not needing to have a permit to carry a gun. He says, people who couldn't pass a background check will now be able to carry a gun. No, it's simply not true. It's absolutely a falsehood lie. And this guy wears a collar. If you are a felon, you will not be able to carry a gun. If you have beaten up your wife or husband in the past, you will not be able to carry a gun. If you are a drug user, mentally ill, you will not be able to carry a gun. These are already laws in the books, and the law pertaining to Minnesota not requiring a permit has nothing to do with that. So the straw man argument is absolutely false. Now, this guy right here, he is my Dakota County prosecutor. And let's see what falls out of his hole.
We really want to encourage a driver who believes he's being threatened with substantial harm in a road rage incident to shoot and kill the other driver rather than calling 911 or simply driving away. I think not.
That is a load of crock. That entire sentence has absolutely nothing to do with the stand your ground law. The stand your ground law doesn't say if you're in a road rage situation, don't call the cops. Even if the stand your ground law was in there and you didn't call the cops, you're a fool anyway. It doesn't give you a pass for not calling the cops. Even though in the state of Minnesota, every state in the union has statutes and or case law that you are not, the police are not required to save your life. There's statute out there. There's a book out there called 911 and Die. Get it. It tells you exactly the Minnesota case law and statute where the police have no duty to save your life. So even if we do believe the Dakota County prosecutor that the stand your ground law is going to encourage people not to call the police in a road rage situation, is simply a falsehood, lie, straw man argument.
Well, there was no vote after yesterday's hearing, and it's unclear if it will get a vote. Similar gun measures are being considered across the country right now, supported by the NRA.
See, and that's the biggest thing, similar things are supported by the NRA. Oh, they just put that tagline in there because if you already have a physical, visceral reaction to the NRA, like a lot of liberals do in Minnesota, my family included, that is going to respond. That's the entire report. Did you hear anything? Why stand your ground is important? Okay, let's go over this situation first. Why stand your ground is important? Because it limits the prosecutor's tools for a political prosecution. when you listen to me, I have a framework: innocence, imminence, proportionality, avoidance, and reasonableness. You need up to all 5 of those to have a successful self-defense scenario. All duty retreat does is remove an existing duty to retreat. If you lose any one of those 5 elements, you cannot claim self-defense. That's why it is very important for duty to retreat, because this is what will happen. When a prosecutor wants into an office, he's doing a political prosecution, all he has to do is eliminate one. And what is the easiest one to eliminate if it goes to trial? Duty to retreat. Because now he is forcing you, the defendant, to prove a negative. I couldn't go this way, I couldn't go that way, I couldn't go this way, that way, up, way, down, couldn't dig a hole. How can you prove that in a here and now immediate situation? The typical example for self-defense, and where you don't have a duty to retreat, is very simple. If it puts you in a more dangerous situation, the classic example is you are having a conflict and the only way to get away from the dude is to run into a busy highway. You're not required at that point to retreat, because it would put you in a greater peril. Now, what the prosecution was going to say is, well, what is a busy street? What is a busy highway? 3 cars a minute, 4 cars a minute. How are you going to prove how many cars were on the highway at that given time? So this is basically what standard ground does, is it removes that. Now, the standard ground law is going to be a greater clarification, and I'll go over that a little bit later, but I want to tell you this. That is the predominant reason why standard ground is important, is to curb the overzealous prosecutor on a political prosecution. Innocence, eminence, proportionality, avoidance, and reasonableness. You must be the innocent party. You cannot provoke the fight. You cannot start the fight. You cannot be in a mutual combat. Eminence. The threat of death or great bodily harm is now. Okay, it's not sometime in the future. It's not sometime in the past. Proportional. Well, that's what standard ground does. It defines proportional force a little bit more as far as using deadly force. Duty to retreat. It defines duty to retreat even to a greater degree. It gives greater clarification for the victim. Okay, standard ground is a victim's advocacy law and nothing else. And reasonableness. This is a very important thing. You heard in the news report, both by the news reporter, the news reader, I should say, and in the meeting, that all you have to have is a reasonable a suspicion, and that's not true. You must also pass the reasonable person standard, not only subjectively, but objectively. So you just don't have to have a feeling that I'm going to be dead. You still need to have the other elements. Innocence, eminence, proportionality, avoidance, and reasonableness. All 5 of those. So if standard ground does go by the wayside, you can remove duty to retreat. Okay. Now this is the proposed legislation for the standard ground. The only thing it does is remove duty to retreat. Okay. The one thing that people don't understand is Minnesota already has duty to retreat in very specific situations inside your place of dwelling. Okay. You don't have a duty to retreat under that certain situation. You do not have to retreat if you are in immediate threat of death or great bodily harm and you have no place to go. If it is right here and now, you do not have a duty to retreat. Again, we talked about the road situation. You have no duty to retreat if it is going to put you into greater peril, like going into the highway, going into a lake, going into a river, in other situations. You don't have a duty to retreat. All this law does is make it more specific. Now we go down to the D section here. Dwelling means a building defined under section 609556 division 3. What it does is expands it a little bit. It gives greater clarity of what Minnesota is really looking for. And overnight stopped accommodations of any kind or place of abode. That an individual, temporary or permanent, is occupying or intending to occupy as a habitation or home. A dwelling includes, but is not limited to a building, a conveyance, and that building or conveyance curtilage. Now, this is very important. Minnesota is one of two states in the nations that does not recognize curtilage as your castle. Curtilage is that outside part of your home where your work, your garden is, the path to the back buildings. This gives greater clarification exactly what Minnesotans need as a protection and gives them a greater idea what exactly curtilage will do for your defense. And again, all it's doing is removing existing duty to retreat that you already have inside your home. Now you'll be able to have it outside your home on your porch. Okay, here it says it conveys the curtilage at any attached or adjacent deck, porch, any other structure, whether the building or conveyance is used temporarily or permanently for the purposes. For these purposes, is a mobile or immobile, a motor vehicle. So what it will do is it give greater clarification in an occupied vehicle, watercraft, pretty important in Minnesota, watercraft, motorhome, tent, or the equivalent. Okay, that is giving a greater clarification of what Minnesota is missing in their black lettered statutes. Okay, forcible felonies. It is in vogue these days to have itemized forcible felonies that will allow you to use deadly force. Okay, gives greater clarification, and it's kind of like a redundant. If someone is trying to kill you, and it is self-evident with a specific tool or device, you are protecting that person or yourself of fear of great bodily harm. If you're using the AOJ triad and the immediacy requirement and the AOJ, ability, opportunity, and jeopardy, this gives just greater clarification. Okay, but I would also say this: don't rely upon it, because then you are assuming that what the act is going on is one of these itemized forcible felonies, like this. Murder in the first degree, murder in the second degree, manslaughter in the first degree, assault in the first, assault in the second, assault in the third, criminal sexual conduct, first degree, criminal sexual conduct, second degree, arson in the first degree, burglary in the first, second, and third, under the certain robbery. Okay. These are going. You're going to have to know the law to the nth degree if you're claiming that the reason you use deadly force because you are stopping a forcible felony, compared to using more of the reasonable person standard of that someone is in immediate peril of life or death or great bodily harm, and that you are stopping the threat on a here and now basis. That is something that you're going to have to be a little bit more careful at. So what the law is doing is it's giving you greater clarification of what curtilage is, giving you a black letter law, exactly expanding the definition of the Castle Doctrine and putting it under the and this is kind of where the meaning and the title kind of gets mixed up. And don't get caught in the weeds. Don't go down the rabbit hole with this. Stand your ground. The only thing stand your ground law does is remove an existing duty to retreat. What this does is it basically expands the Castle Doctrine and gives greater clarity to the people of Minnesota in defending themselves in a proper and legal way. Okay, this is the other thing. Good faith includes honesty in the fact of conducting the act. Imminence. So imminence is still going to be part of it, and it never should, and it's not part of it. So whoever says that you no longer need to have an immediate threat of death or great bodily harm, all you have to have is a fear of bodily harm, is disingenuous and is just a liar. Okay, vehicle. It expands it to vehicle. It gives greater clarity of the victim, of what they can do and what they can't do. Prevent the felony. Preventing the felony of an individual in the dwelling, to resist and prevent the individual's reasonably believes, again, here we go, reasonably believes is an offense or attempt to offense that immediate exposure the individual or other person to substantial bodily harm, great bodily harm, okay? All this does is give greater knowledge to, this is a victim's law, okay? This doesn't expand the law and make this a wild, wild west. This just doesn't happen. What I will concede that this law is lacking is any immunization to civil lawsuits. So if someone breaks into your home, you happen to defend yourself and they die, the family's victim can't come after you. That's what's missing in this law. That is a big thing. What I also would like to consider is, you know, some people really say that stand your ground. All you just have to do is sit there like a stubborn mule. It's not true. You still must have to be reasonable in standing there like a stubborn mule. Okay, you cannot be an unreasonable person. 3, 2, 1. The stand your ground law for duty to retreat isn't designed for the physical fight itself. It is designed for the fight in the courtroom. That is it. And so the duty to retreat isn't some mythical, magical thing that all you have to do is have a feeling and you can kill anybody you want. Is simply not true. Now, what Utah has is it is a stand your ground state, but it's really considered a soft stand your ground state. If it does go to trial, and if it goes to the finder of fact, the jury, the finder of fact can still put duty to retreat on the table if they feel that you acted unreasonable. Okay? Specifically, you know, in the third section. There is precedent in California, in Utah, where the finder of fact can still put the duty to retreat on the table if they find that you acted unreasonably. Now let's go to the Texas statute. Okay? Texas Penal Code 9-32, all the way down to subdivision D. For purposes of the section A2 in determining whether an actor described in section C reasonably believed that the use of deadly force was necessary, a finder of fact may not consider whether the actor failed to retreat. Texas is what they call a hard stand your ground state. I'm not opposed, and I think it is reasonable to have the language in Minnesota that the finder of fact in Minnesota could put duty to retreat into the equation again for unreasonable acts. And what do I think is an unreasonable act? Let's just say a dog run in front of you. You hit the brakes. Someone behind you slammed into you, pushed your car 150 some odd feet in front of you. The person back of you, his radiator's leaking, he's not going anywhere. He gets out of his car and he's screaming at you, "I'm going to kill you!" Well, he's swinging a bat and he's starting to run at you. You're, let's just say, a good 75 yards away, and and he's not really a fit man. He's coming at you, well, I'm going to get to you, I'm going to, kill you, you MF thing, and he's running, he's probably taking about a good 20 seconds to get to you, and you're sitting out your car and you're saying, Minnesota is a standard ground state, and I don't have to move because he is dissing me by telling me he's going to kill me. When all you had to do, your car is still running, is get into your car and leave. To me, that's necessary. That is what a reasonable person will do. But in Texas, since it is a standing ground state, you can stand by the side of the road and wait till the guy gets into 21 feet and shoot him. Whether I believe that is right or wrong, that's for Texas to decide. You still must have all 5 of these, and all standard ground does is remove an existing duty retreat. You don't have a duty retreat inside your home already. You don't have a duty retreat if it is immediate, and you don't have a duty retreat if it will put you in greater danger. All this law does is specify in greater detail forcible felonies, using deadly force on forcible felonies, describes curtilage a little bit more, and really expands. It doesn't expand the gun law. All it does is expand the square footage on where the Castle Doctrine and duty to retreat is and isn't required. I hope this helped. Just listening to the news, you think that stand your ground is some evil kind of thing, and it's just all subjective, where you can just sit there and start shooting anybody you want because you have a feeling. Just is not true. My name is Jeff. This is Castle Doctrine, your home defense network. I hope this helped.